The case against Richard Allen continues to get more and more dramatic by the week. This week, not being any different whatsoever. Now in question, Judge Gull and some of her findings, some of her ways that she's been conducting this case up in question and going all the way to the Indiana Supreme Court. Here to discuss some of these filings and what exactly is going on, because it is a convoluted mess some days when you're trying to decipher this. Bob Motta, the defense attorney, the podcast Defense Diaries. Bob, you are on this one all the time. What is new with these filings, and where are things going here with Judge Gull and her involvement in this case, or maybe lack thereof, depending on what happens?
So, hey Tony, how you doing, man?
Great.
Uh yeah, it's a very, very active case. It went from not much happening prior to September to full speed ahead into crazy world. So I think when we last spoke, uh I think I'm trying to remember what the last thing so many things have happened. I think that it had been that I was in there on Halloween, right?
Hmm.
And Brad Rosie and Baldwin had filed their pro bono appearances, had showed up in court. Judge had a little, I wouldn't call it a hearing. She had kind of a session in court where
Hmm.
she basically let Rosie say his piece and then instructed Richard Allen, I understand what your desires are with respect to these two gentlemen representing you, but I just can't do it. I found that they've been grossly negligent in their representation of you, and I can't allow them to do it.
Sure.
So that that was that, and then we end up getting in the last week since we spoke two petitions filed, and oddly enough, they're not filed by either Richard Allen's new counsel, which are Scremin and Labredo, uh, and it was also not filed by uh, his old counsel, either Allen's old attorneys, Baldwin and Rosie.
Hmm.
Neither of them prepared these petitions. It's an extraordinary remedy, and just kind of in layman's terms, what it means is that uh, lawyers are going to a higher court, in this case, the Supreme Court of Indiana,
Hmm.
and asking them to step in and order the judge to either do something or to not do something.
Yeah.
And so the first one that was filed by three lawyers, three friends of the court, will entered limited appearances, like they don't represent Richard Allen in the underlying case in the trial. All right. So I don't want people to be confused by the fact that we've got additional defense bar attorneys that are stepping up because they perceived that there's been a wrong that's happened here in this case. And the defense bar is, pretty tight knit in
Hmm.
general, when they're looking at it from afar, or in this case from a near in Indiana, and they like I said, they think that something has gone awry. You've got people that are willing to donate their time and resources and jump into the fight. So you had these three attorneys, and they prepared the first writ, which was essentially attacking the judge's um, management of the docket, the court docket.
Hmm.
Okay. Because the beef has been that she seals documents, she removes documents that have been filed by the defense, like in their entirety. She's basically trying the case in the dark, is what the long and the short of it is, as opposed to I mean, as the public goes, we have the right to see all filings in a case. That doesn't mean if there's evidence that's attached or exhibits that are attached to these petitions that contains inflammatory type photographs or something that might pose a danger to a witness or something like that, they will file it confidentially, meaning that the public cannot gain access to it. But as far as just regular pleadings and filings, um, the writ and the petitioners who drafted it, their position is that she violated the public records for courts access rules, and that they're very strict. The attorney who actually drafted it is kind of the wizard of those rules. She knows the rules backward and forward. Her name is Maggie Smith, and she basically pointed out every violation of the rules that the judge has made with respect to the docket, and pointed them all out in pretty concise fashion. And I mean, there's a lot of problems. And I mean, you and I talked about the fact that, I can look at that docket and have no idea what's going on in that case. And that's not how it's supposed to be.
Why would
Even
she?
people,
I guess why? Why? I mean, if you were to speculate on why she would do this, I mean, it seems like it opens up the door to all of these problems that we're seeing right now.
it really does. And I don't have an answer for it. I really don't. I'm certainly not of the position that Judge Gull is trying to specifically railroad Richard Allen. I don't think she's in cahoots with the prosecution or anything like that. So if you take that possibility out of the equation, it leaves me wondering why myself. I don't know. I mean, it's one thing to keep, like I said, sensational or graphic photographs out of the public eye because you don't want that before trial, because that does hurt the defendant really more than anybody else. You obviously don't want the victims' families to have to see that kind of stuff be out published in the public either. But in terms of like the legal process, I mean, the defendant, Richard Allen, who is of concern to the judge. So, yeah, I mean, that would explain that. But as far as pleadings and filings that have taken place, and the fact that she doesn't prepare court orders in a timely fashion, and that she doesn't set things for hearings, that there's been pending motions and responses by the state that are just floating out there. It's puzzling, man. And you're exactly right. The end result is you get
Is it
this
just
nightmare.
sloppy work? I mean, at the end of the day, I mean, maybe nothing more to read into than just somebody who
It's
maybe doesn't like their job much anymore.
But, like,
I
the
don't
the
know.
ironic thing is she has made, like, 3 runs to get on the bench, not through the election route, but
Mhm,
by, trying to get appointed, and she's been found to not qualify,
mhm,
I think all 3 times. You would think if that's your goal, which clearly it is, based on the fact that she's done it 3 times, that you would not have a docket that looks like this on the biggest case in Indiana history.
mhm.
It's puzzling to me. I don't know what she's doing, to be honest with you. I really don't have an answer. It's very bizarre to me. Um, and then so that thing is pending. So that gets filed. The judge has to go. The attorney general then has the option to represent her in the action. The attorney general declined to represent her in the action, and so she had to go out and get private counsel. So she hired a couple of attorneys to handle that. So, and that actually happened. That was filed the day of the hearing on the 31st, but I don't think that we talked about it.
No.
Okay. So, because I think when we spoke on it, I wasn't even aware that it had been filed.
Mhm.
Because when you file something with the Supreme Court, it takes a minute for it to hit because um, it has to be approved to be filed by the Supreme Court. And like I'm not going to bore your listeners with the kind of the legal mumbo jumbo of it all in terms of the argument, but it's an interesting motion. Frankly, I anticipate that will be granted. That writ of mandamus will be granted, and the Supreme Court will direct her to put everything on the docket. Like there was a thing where, like, kind of one of the bigger points is and I know you haven't followed this case as closely as I have, but when she was sealing everything, all this stuff, including pleadings, all kinds of stuff. They did a doc drop like on June 23rd of like 118 documents that she had previously had sealed or listed as confidential for, since October, since he was arrested, Richard Allen was arrested. And then when she puts him on the docket, she doesn't really put them on the docket. She says she makes them accessible to the public, and they create some website that's really, really difficult to use. And you really have to like figure it out. It's not like where I can go onto the docket for, the Indiana court system and typically type in the case number or the defendant's name. It'll pull up the entire docket. It'll show me when things are filed. It'll name what the document is. And, I go from there. With these 118 documents, what the petitioner is complaining of is that number one, they were all stamped as being filed on the same date of June 23rd. And the reason that that matters is because the docket is all that the appellate court has to go by.
Mhm.
So if Richard Allen is to be convicted and he wants to at some point appeal his conviction, the appellate court is going to be relying exclusively on the record, on the docket, on the court records. And when they get this mess coming from her, they can't make heads from tails, so it's a real problem,
Mhm.
like in many different ways. It's not just like well, big deal, so she didn't have things where people could see him. Well, it's a big deal because when then she then drops these 118 documents and all puts them as being filed on the same day, it has a huge effect in terms of when things were filed in the case, and for them to get a clear record of what happened in the case. I mean, the appellate court, they're not playing around. Like, you're dealing with very specific issues. And again, their entire analysis is based on the record of the trial court. So when you have that going on, it makes it near impossible for them to be able to do their jobs effectively, which ultimately affects Richard Allen's rights,
Sure.
defendant. So fast forward to Monday. So you've got Baldwin and Rosie who have been tossed from the case. You've got these two Allen County, her hometown attorneys that she's appointed, and you're wondering, well, are Rosie and Baldwin, are they going to continue to fight? What can they do next? What can they do to try to get back on if they want to? Because remember, they had filed their own pro bono private appearances on his behalf,
Yes.
which changes the Sixth Amendment analysis in terms of right to counsel. Because you know, typically it's thought in many of the districts that people that are appointed indigent people that are appointed attorneys or public defenders, that they don't get any choice in that matter.
Mhm.
Like, you don't get to pick and choose. No, I don't like this lawyer. Give me another one. It's like whoever you get appointed as your lawyer. The question then became, because these guys worked on the case for 11 months, worked very hard on the case for 11 months, created a attorney-client relationship with their client. He wants them as his lawyers unequivocally, and is stated as such in a written letter to the judge. And she still removed him. And like, you just have to try to think of that in a situation like, imagine that you've been arrested for a crime, and you've been appointed a couple of lawyers, and these guys work on your case for months and months and months and months, and you think they're doing a great job for you, and you're optimistic, especially like, imagine if you're innocent.
Sure.
And you've got these two guys that are fighting like hell, to try to make sure that they're not going to have an innocent man go to prison. And then all of a sudden they're stripped away from you. Now they're stripped away because there were a couple of leaks. The second leak was more egregious, and what was leaked were crime scene photos.
Mhm.
And the story has been that they came out of the defense attorney's office, Baldwin's office, that a former friend of his, close friend, who was an attorney. So ultimately, what happens is I forgot what was I talking about? I
You
was
were
talking about like specifically.
Yeah, we were talking about, the Judge Gull, the attorneys being pulled off of the case.
Oh, right, right, right. Okay, so essentially when the leak happens, the judge has had enough.
Mhm,
She's like, this is it's too much. I find you to be no, grossly negligent, is what she said in open court.
mhm,
Now the problem with that is that she did that all back in chambers. Like, so I was sitting in the courtroom on the 19th before the 31st. The 31st was like a circus, but the 19th, which I think we talked about it a little. I don't know how many details we got into it though,
yeah,
because it's a fascinating and really screwy like set of circumstances. But they're all back in chambers, and a lot of it came out after the fact, probably after we ended up talking. Um, and essentially what the defense is alleging is that she ambushed them,
mhm,
that there was no notice that they were going to have the hearing. They show up. She gives them what I call a Hobson's choice, which is really no choice at all.
yeah,
And she says, look, I'm either going to fleece you publicly, and I've granted cameras to be in the courtroom for this one hearing. She paraded 9 cops in, or the state did. And she says, I got witnesses out there. They've done an investigation. So I can either do that, which potentially has ramifications for them with the bar, with the Indiana
mhm,
State Bar. It could create a real issue for them. The complaint more likely than not would occur, and it could result in them being suspended, or I don't think it would rise to the level of being disbarred. But so she says, or you can withdraw. So Baldwin makes an oral motion to withdraw. Rosie says, you know what? I'm going to put it in writing. And so in the interim, he turns around over the weekend, and like midweek the following week, he files a couple of things. One, a verified declaration that he is still counsel for Richard Allen, and two, a motion to disqualify Judge Gull from the case.
mhm,
And then he makes his arguments. And so then you fast forward to the 31st. She's got her two appointees, the new guys standing in there. You got Rosie and Baldwin in there. It's super awkward for all of them. No one knows what's going on. No one knows what she's going to do. So she basically ignores these Baldwin and Rosie initially and says, "Oh, Mr. Libredo, I see that you've entered or filed a motion to continue the trial." And Libredo says, "Yes, Your Honor, that's correct. We just came out of the case. We need time to be able to catch up and familiarize ourselves with the evidence." And from that point forward, then she goes to Rosie. Rosie gives his speech, uh, and then she basically looks at Alan and again says, "I'm sorry, sir. I know that's what your desire is, but I can't do it. I can't let these men represent you." And then another attorney who was representing Baldwin steps into the wall of the courtroom, and he wants to make a record of it, of exactly what went down from his client's perspective back in chambers. And
yeah,
they're saying that they were coerced into withdrawing, blah 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 blah. And he makes a real solid record, as to what the defense's theory is. So again, fast forward to this Monday, and another writ is filed by a woman named Karen Weinecke and another gentleman named Mark Lehman, who are both Indiana attorneys. And this particular petition for a writ of mandamus, which again is an extraordinary remedy, and they're asking for the higher court to either do something or not do something. And in this case, they're asking them to number one, stay everything that's going on in the trial court, which means put it on pause. Don't let anything happen while we're getting this all worked out and
yeah,
resolved. Two, that they reinstate uh, Richard Allen as appointed counsel. Okay. Which means that they would still get paid by the county. And three, that they remove Judge Gull from the case. So it's whether or not it's going to succeed is hard to say.
mhm,
They make a really strong argument, but it's a big move for the Supreme Court to do it. To take her off the case is a big move. To put them back on is a big move because if they basically if they put if they put Rosie and Baldwin back on, they're basically telling the judge that you screwed up,
Yeah.
and that's a big deal. Like they're not chomping at the bit to do that as a general proposition, you know. But I mean, in my estimation, it's called for. In my estimation, this case has gone off the rails, and when the only thing that really matters at the end of the day is trying to get justice for Abby and Libby,
Mhm.
and that is intertwined with making sure that Richard Allen gets a fair trial and then he's represented by the counsel of his choice that are going to put forth a zealous defense so that if he's found guilty, we can feel secure in the fact that he had the guys that he wanted, who we know worked the case as hard as they could,
Mhm.
and the state had enough evidence to prove that he was guilty.
Is there anything in there where should he get his attorneys back, Baldwin and Rosie, and this goes to trial? Let's say he is found guilty. Uh, does that create an appellate issue down the road because of essentially what took place with the evidence leaking out of their office, or is there something where before they get reinstated, there'd be a hearing and it said, "Look, you can't go back on this issue if you really want them."
Well, I mean, there's a bunch of ways it could go.
Mhm.
I think if it stays as status quo, that they have an absolute slam dunk Sixth Amendment
Yeah.
winner. So if he gets convicted, I think he's going to get a retrial.
Mhm.
I think it's a structural error, meaning that the act itself was just incorrect. And I'm talking about stripping him of his counsel of choice because when they entered their pro bono appearance as private counsel, it changed the analysis. Because, like I was saying, in this country, it's been, even though it's inequitable, that indigent defendants, when they're appointed attorney, that you don't really have any choice in the matter.
Yeah.
The argument is that, that there's continuity there, that they've created this relationship, that it's changed from just being appointed counsel to now it's something different. But the argument has always been that you didn't handpick them, you didn't pay them. It's you don't have the right to complain that they've been removed because we gave them to you to begin with, you know. Whereas when these guys fell on the sword and entered their pro bono appearance, which, so people understand, would financially ruin them. Like, to try a case like this, you can't try anything else. There's nothing else you can do in your practice. You can't take on new clients. All your existing clients you're handing off to other lawyers in your firm because you're focused on this one case because it's that kind of a case. It's a huge case, and so so that leads to this second petition and a couple other things they asked for. So everybody has been asking for, including Rosie initially, was the transcript of what happened back in chambers because allegedly Gull said that it was being recorded, which means that there was a court reporter in there. She was taking a transcript of it. And I actually, uh, myself and a friend and I had emailed the clerk and the judge because I was sitting in court and David Hennessy, the one attorney that I was talking about that was representing Baldwin, told me that, look, there's an act in Indiana where the public can request a hearing, an audio hearing of the record, that I could go in and I can tell the judge or the county clerk or the person who is basically the court reporter, look, I want to hear this. We've got a right under the act to do it. And so Gull actually emailed me back and said it was private and confidential.
Mhm.
So not only did she tell that to me, she also told it to the attorney that filed the brief. Okay, the petition and the brief, who wanted a record of the transcript. She wanted to see what happened back there. She needed to know. And Gull told her the same thing. It's confidential, even though that she has entered a limited appearance in the case. So it's crazy. And then today, a new order just dropped that the Supreme Court just told Gull, look, Okay, we know that counsel has requested a copy of the transcript of what happened on the 19th in your chambers, and you have till the 16th to either prepare a response as to why you have refused to turn that over or you're turning it over. So
Are there
they
any
put
valid responses that she could give as to why she's not turning it over? Or, I mean, is this
not
something where it's just the reason is because it's going to not look very good on her.
I mean, that's what I'm assuming.
Yeah.
No, I mean, there's no valid reason under the law.
Yeah.
There really isn't. I can't think of any reason why she could tell the Supreme Court of Indiana, sorry, but I can't show you the docket of what happened back in chambers. It's just she's going to have to turn it over. And then at that point, the cat's out of the bag.
Yeah.
I don't think she thought it was going to play out like this. I don't think that she thought these guys were going to fight,
Mhm.
and it's putting her in a really bad spot. So there's a lot of pressure being applied to her. So we'll see how it plays out. But um, and there's folks out there that think that the fact that the leak came out of the defense attorney's office is incredibly egregious. I don't feel that it's quite as egregious as everyone else does on that side of it because of the fact that it was contained. And beyond that, it wasn't as it would be a different situation if we were to have found out if she had had a hearing, which she should have done. Like even people on that side of the argument
Yeah.
agree that she should have had a hearing so that all the facts could come in.
Sure.
Had it turned out that Andrew Baldwin had like personally disseminated the pictures to somebody to
Yeah.
leak, that's a different story.
Different story. Yeah.
That's a completely but if it's a buddy who was an attorney and a longtime friend comes into the office and skulks around and gets into the war room and sneaks pictures and then goes out and it's like people are like, "Oh, they should keep them under lock and key." That's not how it works. I mean, like a prosecutor's office is a very secure office. Like the doors are locked. There's a receptionist up there. They just don't let anybody in. A private attorney's office is much more open, especially when you're inviting like somebody that you think to be a close friend of
Yeah.
yours in, and the guy just like sneaks off and surreptitiously takes photographs without your knowledge and then goes out and disseminates them. I mean, you're not gonna like in a case like this. I keep trying to explain to people that they've got like what I would call a war room
Mhm.
where they have all the evidence out. They've got probably cork boards. I mean, you're trying to work your case,
Yeah.
and it's just not reasonable to think that every time you go in and out of that office that you're locking the door
Yeah.
in your
Yeah.
own office. It's just not
Yeah.
how it's
It,
done,
yeah.
you know?
And it's you're reasonably thinking your friend, a longtime friend, would never do something like this. They, in fact, are
Ever or
betrayed as
or any of
well.
your
Yeah.
employees,
Exactly.
it's just not something that's like this isn't like it was a random client
Yeah.
wandering around, somebody who called, made an appointment, had no intention of hiring them.
Yeah.
Baldwin leaves the room and this fake client goes out and this is like a buddy of his,
Mhm.
like an attorney that went
Yeah.
in and did this, like completely betrayed the guy,
Yeah.
like you never, so I just have a different feeling about it. And I certainly don't think it rises to the level that she could remove his counsel of choice, which they were at the time that they entered their appearances pro bono. I don't think it's anywhere near that. There were many other remedies that she had at her disposal. She could have fined them. She could have put them in jail. I mean, there's a lot of sanctions that she could have done as opposed to removing the two people that are fighting to the death to try to make sure this guy, if he is innocent, doesn't get convicted.
Yeah.
So yeah, it's a mess, man. But the
Yeah.
16th is a big day on it. That's when responses have to be due. But, knowing this case, there's going to be more stuff coming down the
Exactly.
pike in between, man.
By next
So
week, it'll be a whole different conversation. It's
for
just,
sure,
yeah,
for
every
sure.
single time. Hey, it's Tony Brueski. If you want more of our interview with our guests, be sure to check out our podcast, Hidden Killers with Tony Brueski. Just search that wherever you download podcasts and press subscribe. Also, you can check out our YouTube channel for the full video version of the interviews as well, under the same name, Hidden Killers with Tony Brueski. Check it out, subscribe, binge, and enjoy. Thanks for watching.